My name is Sergei Shvetsov, by the way, and I represent the central bank. My colleagues are Mr. Ivanov, who has a lot of titles. He's coming now. And Roman Bizenko, who is professor at the School of Private Law at the President of the Russian Federation. So this session is rather interesting. We'll discuss 5 issues very quickly, after which you can suggest your questions. And on the whole, this session is about the future initiatives. Right now, Duma is in the process of adopting a lot of various laws, draft laws, and so on, which is related with the development of the Russian financial market from the point of view of defending the rights of consumers, then quality assurance, quality control, and so on. We all know about those, and we're not going to dwell on those. We'll focus on the initiatives that are due to emerge this coming fall or maybe spring. These initiatives are absolutely new, and some of them even evoke doubts of some of the specialists, so the discussion must be interesting. The first issue to discuss is about building the procedure for sustaining the companies, just for the providing sustainability of companies operating on financial markets, which is related with the transfer of the property rights, the change of owner, and so on and so forth. We have huge experience accumulated on the banking sector, and central bank has a lot of tools in its hands. It's just engaging all kinds of sanation experts, liquidation, bankruptcy. Then OSV organization is a mega liquidator. Then we are discussing the setting up of the mega senator, and the banking sector has been developing in this direction for quite a while, actually beginning with the beginning of the previous century, and even before that, when the Russian financial market was in its emergence. But as for sanation, liquidation, turnaround, and of other financial institutions, like just professional participants of the security markets, here we have some negative distance in regard to the banking sector, because all those financial institutions, they also raise funds, attracting some of the monetary funds of the population. And the central bank, as regulator, must be able to protect the rights of consumers. And that's why we've prepared a draft law, which is about the implementation of the key attributes for the efficient regime of the counteraction to the losses that can be inflicted. And just that is about the but maintaining the sustainability of such institutions even when they face challenges. So we break them down into 3 categories. The infrastructural, here we have monopoly. Only one exchange on the stock market, only one central depository, one central counter agent, and the ordinary norms of bankruptcy do not work here, because they work in online regime, and this is the prime mission, but not giving back the money to investors, as is implied by the normal norms. So these institutions are a separate caste, and what the government is trying to do to provide for their sustainability is about this just change of manager, and they are maybe not employees of the central bank. They must invite some other outside managers, but it should be done within 1 day, against the law of the pending now. So if there are any problems, and if the company just is on the edge of bankruptcy, it is mandated for it to change the team of managers and continue operating online continuously. And this is rather a debatable issue, because here we have a conflict between the interests of the investors and the users, and taking into consideration the monopoly that has been established on the Russian market. Regulator is to defend the rights of the users and the interest thereof. Hence this idea of active managers. So the second group of institutions, it's solo business ones, it's insurance companies and pension funds. Likewise, the rest of the banking sector, such companies should stop their activities, losing their license. They are not to continue their operations in other spheres. It's either bankruptcy if they have physical deficiency of capital, shortage of capital, or if the situation arises when other norms and laws are violated that are non-financial in their character, but it's just violation of some conditions of interaction with the consumers, which is a new idea for a new entity for the Russian market. This is when we either stop their, suspend their licenses, or withdraw them, just because they violate the norms of interacting with the consumer. This is defending the rights of the consumer. So today, only non-state pension funds are liquidated by ASV. The State Duma has some initiative that is now considering on some insurance companies and others, but it should be about all the institutions that operate in the stock market and attract the money of the consumers. We followed the American model, and probably you know that segregation of broker accounts has been implemented. So clients' money, between clients' money and the broker's money, there is a demarcation line. But if the client allows broker to use his or her money, then it can be allowed. But now all the contracts are now being signed with this item. So broker companies can make use of the client's money. So which means that recalling the license, the central bank further on cannot interfere into the resolution of conflicts between brokers and their clients. It's a big problem, so that's we think, and we think that central bank does have the responsibility to kind of monitor the whole process from the beginning to the end, like it is done with insurance companies. And we have, as of today, a lot of recalled licenses and a lot of requirements and demands that are not satisfied, and we can't do anything about that. So this innovation must be implemented. So the next item in this regard are the operations of the transfer of property of the company to other entities before the company goes bankrupt, because we are interested not only for all the creditors to get their pay, but also in maintaining goodwill, because the dead company and just ongoing concern companies and the alive companies, these are different things. If an insurance company is still alive, that means that they do continue using the technologies to serving clients, and then there is an inflow, and this inflow finances the outflow. As soon as the company stops, we recall the license, then the company may lose its goodwill and the assets, and they include personnel, position on the market, and so on. They turn into liabilities because personnel wants to it, and they must pay their rents, they must pay for their electricity, and so on and so forth. So the production process, which previously generated outflows, becomes a burden. So to avoid such situations, we need a system that would enable the central bank, even at the earliest stages, to diagnose the challenges. And if changing the management team does not help, if they fail to reach agreement about correcting the mistakes of the company with the active management, then this company must be forcefully sold. It must be mandated for them to sell the company. So this is the initiative that we are putting forward this fall. Then talking about bankruptcy, also the issue of the responsibility of the board of directors is important. So now implementing the code for corporate governance, we reinforce the role of the board of directors and to set the first person and then just set the risk, assess the risks and so on. But directors, they bear minimum responsibility, and that's a big problem, because if we take developed markets, the responsibilities and obligations, they're just rights and responsibilities, they go hand by hand, and this principle must be active in our whole society. And if the company is still operating well, the responsibility of the board before the stock owners, it's one thing. And when they face financial challenges, then they must bear responsibility before creditors. And in the Russian law, there is no discrimination between those. So the director making decisions should realize what responsibilities he has. He is responsible with his good name and financially. If his activities lead to some damage, then he must be held responsible for this, and that should be also dependent on the stage of the process. So in total, this is what we're going to initiate, and we're going to make suggestions about the changes in the law on bankruptcy. And I believe that the final stage of the company's life cycle will, if it is corrected, will enhance the trust, because mistrust emerges because the procedures of bankruptcy of financial organizations are not regulated properly, which reduces competition and which concentrates physical persons only onto the major companies. But we do want to have middle-sized and small companies, because only if this market is saturated with suppliers that will make the tools accessible for the citizens of the country and enterprises active in it. So this is what our vision is on the first item. And I know maybe you would like to share your views. So this the director, Alexei Gennadievich, director of one of the departments of the central bank. Good morning, dear colleagues. I think that Sergei Anatolyevich has given you a detailed picture and approaches that we exercise. I'd like to focus your attention only on some details, taking into consideration the experience of central bank as mega regulator. We see how various processes evolve in different types of organization: banking organization, non-credit financial institutions, credit financial institutions, pension funds, and so on and so forth. And from our viewpoint, the models that used to be tested on bankruptcy can be used, extrapolated onto non-credit banking financial institutions. The reason is that withdrawal of the license should entail the mandated liquidation of the company or even the bankruptcy. This will demand serious restructuring, not only in the legislation on bankruptcy, but also the legislation that regulates the activities of organizations in question. In many cases, we face the situations when vice versa. First, there is a court. So they appeal to court and just about the annulation of the business, and only then they submit for bankruptcy. So to satisfy the claims of creditors, so this issue becomes beyond the scope of regulators. And same about the liquidator in charge, appointed by the court. So one of the first examples is the bankruptcy of the law on bankruptcy was discussed at appropriate commission sittings at the government of the Russian Federation, and in the nearest future we're hopeful that even probably during this session, some suggestions for amendments will be made. So the core idea of those amendments is that insurance organizations, likewise credit organizations, will have one liquidator. This is the Agency on Deposit Insurances. So this agent will be the main controller of the bankruptcy cases and insanation And we see how efficient the processes of the financial sanction have been, the ones that have been under the umbrella of the said agency. I believe that this experience will enable to improve the situation and increase the trust in the towards financial sector.
Anybody wants to add something? Dear colleagues, I just would like to speak about not only about the bankruptcy procedure and the bankruptcy itself. However, why are we initiating bankruptcy procedure? In order to repay the liabilities and also bringing things from the judicial practice. So I see two major problems here. One is interpretation-related problems. It's interpretation of the proceedings by court. And the other problem is a system-related problem, which is mostly about application of legislation. I'll start backwards from the second one. So just finding somebody liable for the debts with the according to the Russian practice, there is a trustee that is basically targeted at the piercing of the corporate veil. So what kind of a deal is that? This is by nature a commercial deal and just a dispute which is to be dealt with by the arbitration, or is it a commercial deal that is going to be dealt with under the general jurisdiction? We had just competition between jurisdiction because one could initiate this act in the arbitrations as Presidium of VAS, Primorie.com case, who said that this is an accessor deal which is to be judged by the arbitration court, and the Supreme Court initiated that not the essence of the relationship is that matters, but whether this person is registered as an entrepreneur or not. So this is a general jurisdiction case. So after this year, we see a new practice which dealt with the general jurisdiction principle rather than introduced it. I've heard some reviews of people who came to the general jurisdiction courts with the bailsman who just basically gave a lift to his wife, and then he paid out some of the debts for the person who leaked his flat, and then he made a very important case. So I think we have to remember about the amendments that are to be introduced in 3 days. We are facing an interesting dichotomy, which is accessor bailing and independent guarantee. As to independent guarantee, it is to be given to the entrepreneurs. So maybe lawmakers in some time will view the new application norms and probably will agree to give this guarantee not to people who are beneficiaries of the company and not officially registered entrepreneurs. So then it will drift towards the commercial disputes domain. And so my comment sounds like a presentation we'll have a brief, so I think it's quite appropriate. So a second little comment is about mortgage. So we have amended our mortgage legislation, and it is now quite effective, but old laws in the old mortgage laws is something that impedes the new law enforcement process here. So collateral law is applied to the mortgage unless otherwise stated in the mortgage law. So formally, they are to be viewed as a priority application laws, but we could switch to general, not to special versus general law, but say that this new law on, so no one still appealed to the court about the Ross Register dealings with the mortgage. So I might add the comments then. So now we're moving to the second issue about the Ombudsman, putting off the Q&A period till the very end. So it's prepared for the second reading. There were a lot of dispute whether we have to propose the simplified version to the people, so whether we have to involve the financial sector in that. However, an interesting norm didn't come to be part of this law. It was a voluntary norm, so this is the right of the Ombudsman to be engaged in the restructuring of debts at the application of the citizens. There are people who have taken loans from different credit organizations, micro organizations and others. And it is not possible to agree things about such number of creditors. The Ombudsman has been performing this function on a voluntary basis. However, it has some defects. The question whether the Ombudsman has to be entitled by the right, by this right without asking the credit organizations, following the principle of being reasonable and not making the creditor's position worse, meaning that if the restructuring entails that the creditors get more rather than they would by bankruptcy procedure, that means not making it worse. So whether it creates certain risks for the financial sector because it might worsen the discipline, and however, when at loss of job or loss of and providers, some natural calamities could trigger off this procedure. This is quite a disputable issue, which I would like to offer to discuss with you today. So, Mr. Ivanov, you are to begin this discussion. Thank you, Sergei Anatolievich. So, asked to put up my presentation, and I'd like to thank you 2 times even. So, one gratitude is for the innovative activities of the central bank, which central bank is the innovator in the regulating sphere and the financial sphere. The second gratitude is that you told about the most intimidating part of the liquidation, where such things like turnaround and liquidation and other bring up the associations with the doctors, because Ombudsman is just a topic for complete delight. So just asking how well you are aware about the Russian or international experience of financial ombudsman, whether you were engaged in such an activity, please raise your hand. So, then I'll use 3 minutes of your time to provide you some more explanations about that phenomenon. I disagree because with Sergei, because I think it's just pure delight. So this is one complete challenge for the constitutional law and the banking law and the civil procedural law, which might be of interest to the legal profession. Financial ombudsman is a special person authorized to regulate disputes in a pre-trial way between the financial organizations and citizens. When 200 years ago in the West, there appeared an idea of the state ombudsman who would provide protection for the citizens from the state, and then there was a logical follow-up of this idea. to extend it to protect the consumer against the giants of the financial industry, like insurance organizations, major banks, and other organizations that, from the consumer perspective, considerably exceed his economic and legal power. So over 30 years, in all financially developed markets, so the question of where to consider disputes has evolved a lot and changed. So if you're in dispute with a financial organization in the West, you don't go to the court. You go to the financial ombudsman, and now we're going to see some statistic in my presentation dealing with that. However, since we're dealing with the legal parameters in the economy, so I would like to use some statistics. So we need to understand the frequency of the legal relationship. So you have you see some two lines, the green and the red line, and some bars. So this is the intensity of disputes arising between the banks and just the citizens, the right line. So these are the citizens bringing legal just claims against the banks who, in their opinion, infringe their rights. And I would like to say personally to Roman Bevzenko, so this line in 2011 has experienced a considerable drop. So the arbitration court just adopted two major practices, 167 and 47 and 167, and just about 30 disputes were resolved, and the citizens just did not have any reason to just push up with that, and so just the financial ombudsman helped to decrease the intensity of the problem. With insurance companies, we did not have such a favorable situation. In 2011 is the turning point, so the green line showing the increase. So about 500,000 of disputes tell that the citizens think that the insurance the right to get the insurance compensation was violated. Now the bars which Sergei was speaking about, these are the disputes arising from the just delayed repayment from the citizens. So 2014 is the All Russia record. About over 2 million claims were filed, 1,100,000. So the claims voiced by the citizens to the banks about 20 times fewer than the other way around. The intensity of the dispute varies a lot. Judicial court statistic also provides us with important instrument in order to establish and develop the ombudsman, financial ombudsman institution. So here's the statistic of the Supreme Court, which can help us calculate the average sum of the claims that were awarded by the three major banks. So it's quite a modest sum. So about 60,000 claimed by citizens from the bank, and 80,000 is the average awarded sum. So it's under 100,000, and it's quite a different situation when we look at how at the sums that the banks claim from the citizens. So it's over 2 million cases, and it's about 300,000 rubles, which is 5 times higher than the other way around, than the citizens' claims to the banks. Responding to such daily needs, the lawmakers in 2011 had a draft law ready that was adopted last year in the first reading about introducing the financial ombudsman. I'm calling this person an ombudsman, but modeling on the foreign Western tradition. So I think it's quite a satisfactory term to use in many similar cases. and they were just restricting the jurisdiction of such courts about the citizens and the banks. So the intensity of disputes prompts this kind of conclusion. And also it introduced a three-tier model of complaints or claims. First, a citizen has to appeal to the credit and financial organization. If he does not get any satisfaction, he turns to the Ombudsman, and only after that he is entitled to just bring a case according to this established procedure in the arbitration court. Then we see an important thing in the international legal experience. So the experience of the British Ombudsman, about 2 million British people appeal to the financial ombudsman for a consultation annually, and about 500,000 evolves into formal claims. So this green box is conciliation. It's not done by the Ombudsman. It's done by the adjudicators, people who work in the service of financial ombudsman, but are not ombudsman himself. So 95% of the applications basically resolved on the pre-trial way, reaching conciliation, and only about 5 come to the Ombudsman for his review. In the system, there is a 4I principle. The first instance, adjudicator, who in 95% of cases resolves the case. The second instance, the second review of the professional lawyer, which results in a certain solution and resolution. So just the principle of 2 eyes, so to speak. The principle of the just a system of appeal inside the Ombudsman's proceedings has not been implemented. One and the same person in the system of the Ombudsman is acting as adjudicator and the person who just awards official decision. And this is what provokes concern from the credit organizations. How we're going to do the legal checkup. So I have just 2 minutes left for my presentation, and now I'm going to speak about the rationale behind the Ombudsman's decision. And I would like to draw your attention to an important idea: protecting the violated rights of citizens. The Ombudsman relies upon the law, and he acts on the principles of legality and rationality. He understands whether there was a violation or not, and the established legal norms are applicable. But when we ask the financial ombudsman to deal with the restructuring of debt, so this is a reverse situation. So the citizen has failed to fulfill his citizen's liability. He is liable to the bank, and there are no legal reasons or some force majeure circumstances or other loopholes so that the person could be exempt from delivering this liability or just mitigating this liability. And in my view, there is a situation when the Ombudsman begins to act as a person who either deals by the notion of the law with this application or governed by the crisis consciousness principle, which requires mitigating the critical situation. And now we're speaking not about the jurisdiction function and jurisdiction-related powers. This is quite a disputable area which is quite far away from the law domain. International experience shows that in none of the jurisdictions, financial ombudsman who protects violated laws, rights of the citizens, has no power to deal with debt restructurization. These are different areas which are delimited. In different jurisdictions, they can be called financial consultants, credit mediators, and others who basically engage in mediating practice. In Germany, it's called this over debt of the citizens. There are 1,800 consultancies active. In Britain, it's a financial or tax consultant or tax advisor who deals with that. So one of the major conclusions I would like to argue is that the financial ombudsman in the Russian Federation by no means should also be entitled to deal with the credit restructuring activities. It happened 2 years ago, just by mere chance, when the ombudsman was introduced as a position, and people started approaching him for restructuring their debts. But this is not within his competence and function. So we have a jurisdictional and just legal flaw here. So he is a credit mediator, just who only can deal with the credit restructuring by the notion of law only. Here you can see the chart, which might invite you to take a closer look at it. And I tried to show how the ombudsman makes makes a contribution to the different arms of courts. So I think that the Australian and Mexican ombudsman experience will be more helpful, because it's more important that people know about the importance of this function. And just as soon as the character of the Australian series just spoke about the financial ombudsman, just the number of appeals to him grew.
Do you have anything to add, Vasily Ignatievich? Well, just a couple of notions. Oleg represents here the regional banks, and I haven't heard the position of the regional banking sector, banking community, regarding the Ombudsman Institute. I think it's double-fold, which we can see judging by the latest presentations. The Bank of Russia insists on setting up this institute. Probably at the first stage, this institute shouldn't deal with the debt restructuring issue. It's the issue of trust towards ombudsman and the issue of whether he or she is capable of coping with this flow of claims coming from citizens. But we feel an urgent need in this kind of institution for microfinancing organizations, insurance organizations, and other types of organizations. This draft law is now in a very difficult situation. There are some hot debates about that, and there we face a lot of problems regarding constitutional law and institutional issues. And we have to resolve those challenges ad hoc, but hopefully we'll manage. Now we are going over to the third issue, which is about making deals with regulator. We have this notion of deals with the judicial system, but here it's a different thing. It's about dealing with issues of market manipulation and inside market. So the process of finding proof on such episodes in the financial market is very labor-consuming. It is difficult to do it quickly, just stopping such practices, or via bringing them to court or criminal punishment of the persons that are proved to be guilty of this practice. This phenomenon really inflicts serious damage to the reputation of financial institutions, and in order to reduce the damage to the financial market at large because of those manipulation and insider trade practices, in developed countries, they have a special instrument. When first the process is of just making suggestion to the financial institution to give up and cooperate, and in return the material burden is relieved a little bit, so then there is no criminal persecution towards such institutions that cooperate, and that enables them to preserve their image. But nevertheless, they have to pay fines, and the money raised through that goes to compensate for the proven damage for the other participants of the financial market who became victims of this manipulation or insider market operations. And the remaining part also just stays within the state budget or goes into the budget of the regulator. In great extent, this procedure is useful because, well, the conditions are not equal, because there are only some specific traders who manipulate, specific managers of specific institutions, but the institute suffers as a whole. The image of the whole institution suffers. And so if we recall licenses, if we, well, just it is another group of the financial market participants that suffer. So the suggested institute will enable us to specify the victims, the guilty ones, and then the regulator will probably increase the degree of resolution of such situations. So actually the dynamics here is positive, and the number of deals of this kind is increasing, but the number of the facts of such manipulation cases goes down. And we are exploring the experience of the BRIC countries, which has proved useful. Some figures to prove what I'm saying. So in the Russian Federation, only before just the documents are submitted to the appropriate body, the procedure takes about 2 years of collecting documents and so on, which means that when the market confronts such practices, cannot feel being protected from such practices. Then follows some criminal trial, administrative trial, and all this court procedure, and then it brings us to the time horizon of maybe 3 or 4 years. As you see, it's a huge time lag. We start several cases per month, and this is growing like a snowball. And we have implemented only relatively few monitoring practices for financial. In Brazil, they have about 6 cases per year. They are comparable on the level of the development of the financial market, but in that country they managed to reach an appropriate level of fear on the financial market, fear of manipulation, and that reduced the number of such infringements. So the damage made sometimes can be up to several hundred millions of dollars, and the upside of such practices is also huge. If you use inside information on the financial market, then you get certain competitive advantage. You give an opportunity to earn a super profit, because you behave differently from other bona fide participants of the market. In order to defend the market from such negative practices, there should be downside, which is fines, some criminal court punishment, and so on. But the procedures that are in place nowadays do not enable to bring the cases to appropriate punishment, be it financial or criminal. So So the counteraction that is just been done is only the disclosure information about the non-bona fide market participants. But who suffers? Just those who are somehow infringed, they lose their certificates, and then they can't pursue their practices, then can't continue occupying their positions. And the central bank in Russia has a very limited possibility of recalling licenses, because we want to show clients the financial state of the financial institution serving them and making their decision on the basis thereof. Not a single client building on the account reports or whatever can even suspect of this or that institution to be engaged in the manipulation or inside trading. So we want consumers to be capable of making grounded and enlightened choice. So departure from this procedure of recalling licenses into the area of paying fines, it's something that we deem necessary to be implemented on the Russian financial market. It will be a breakthrough innovation, unprecedented innovation, but it's a specific step. We should learn from our own mistakes and the mistakes of our colleagues, but we should also learn from best practices of just the colleagues we cooperate with. Have you anything to add to that? No, because of the shortage of time. Let us now go over to the next topic, which is what does it mean just to control and monitor the emitters, and where are the boundaries of the powers of the Central Bank of the Russian Federation? As has been said, we are now on the threshold of a large-scale reform. It started with the fact that as of the 1st September in the Civil Code, new norms have been implemented, which in 2014, and we have now public and common categories. And we started with common communities. We adopted the corporate behavior code together with the government, and it is being implemented in state-owned companies and will be implemented in all public institutions, and we do have the need in such. It is in the interests of the stock owners. Then the rules of the listing require that, and also we would like to attract new investors, new stock owners. So it's about building goodwill around each legal entity. And especially it will be useful for attracting potential investment capital. So the code stipulates the norms of behavior, but also the regulator, as of now, does not have any powers, specific powers, or even understanding about the boundaries for the regulator as a control and monitoring institution, and where its responsibility begins before the stock owners and before boards of directors and so on. You probably know it very well that today we have a lot of court cases against Gazprom, a very well-known company. Gazprom, in some of its deals, in acquisitions, they made no offers to the minority interests. And there are some cases in the Supreme Court and so on, but nevertheless, Gazprom is still failing to perform its obligations. In this case, it's clear we have some powers and we use these powers. But then there are some other cases. When the company goes bankrupt, must the regulator sue the board of director members, urging to disqualify them, or just to take some fines from them in favor of the minorities? Then should regulator disclose information, where, like in the United States of America, after all, Saxman, and then disclosure of information entails criminal punishment. So if this is one of the functions of the central bank, must it be really implemented? How much should we interfere into the cases with non-public companies? Where stock owners, they know each other and probably they do not need the interference of any outside regulator. And currently we are at the crossroads and we do not have any ready concept to answer this question. And that's why I would be interested in hearing the opinion of my colleagues. Where is this borderline for the powers of central bank as regulator? Where is that line beyond which it shouldn't interfere? Thank you, colleagues. Well, Sergei Anatolyevich, I think you've demarked this borderline. It's just we have public and non-public companies, and they are very well determined by the law. If it is public money that is used, then probably yes, this unlimited circle of third persons requires the interference of the regulator. If it is non-public company, if it is private company, then probably the regulator, like central bank, should not interfere. And I'm confident that this kind of assistance on the part of the mega regulator, it's only the sphere of public companies. Так, микрофон. Well, the soft law concept in the Russian Federation mentions then you mentioned this corporate behavior code and so on. And probably these codes should be implemented, but they are not legal norms. Currently, the banking associations are on this way. The specificity of the current situation in Russia is about the legal norms being less and less generated in the normative acts and laws, but they emerge in big business practices. And then on the level of professional unions or professional or self-regulating organizations, they are implemented in the norms of what is called in the Anglo-Saxon law, soft law. So until in our science of law we have this kind of concept saying that such behavior rules are enforceable, until we have any mechanism to enforce those behavior rules, we are not going to have easy time in regulating such situations, how to implement those behavior law norms. So it's going to be very difficult until the professional communities arrive at understanding and adopting such concepts. As a follow-up of this discussion, may I ask you a question, Roman? Indeed, you've drawn a very clear-cut line between the spheres where the regulator can interfere. In this regard, do you think that the legislation about the defense of the rights of investors will require any changes? Because in some cases it's about forcing some emitters to pursue certain steps, and also it implies certain punishment, so from administrative penalties to whatever. So do you think that just the change that we had in 2014 should entail some changes in these spheres of law? Thank you for this question. Actually, I think that you've mentioned another very fine borderline. When on the open market, I attract funds, not being public company, but I just attract funds by issuing bonds or some other things. So mega regulators should feel this very subtle borderline. When those third persons are corporate members, it's one thing, but when you defend the interests of the third persons who are creditors, it's another story. If they are stock owners or other security holders. So these are Euler's rings, in fact. And if I'm a public company and if I issue stocks, and then the stock owners must be protected by the active position of the mega regulator, including the minority stockholders. But we shouldn't mix them up. The tool set that is given to the regulator by the security law, it's one thing, but another thing is a tool set that is related to behavior codes. And for the final issue now,
Thank you. So I'll change the vein of our conversation a little bit, and I will speak not about such a thing that a differentiation of responsibility for just a civil servant and the legal profession representatives in financial market. Rather, I'll speak about the pending reform of the coercive measures to be taken to ensure liability of the non-credit organizations. Say it's carried out in the vein of the Duma discussions in the new code and the related regulation, legislation that regulates the activities of a specific actor of the financial market. When the Bank of Russia became the mega regulator, we inherited about 45 different cases in administrative violations, which we can apply to different subjects in the market, for the violation of the investor rights, for the offense that arises in the sphere of the corporate legislation and financial stability. Both behavioral, economic and financial factors can give rise to the application of coercive measures. And the number of these cases is quite great in average. However, we have a little bit different experience with the credit organizations that just resist our efforts, resist to letting the administrative code punishment leak into this field. So one is not applicable. In fact, so one has not been used for 2 years, but when 2014 it was cancelled. And in our practice, we proved that applying as a means of control, this is quite an effective and proper thing to do. However, we view this situation as the body that engages in management in terms of the effectiveness and non-effectiveness of the measures taken. So we would like that all the players follow the rules and they safeguard the interests of the counteragents and clients. But we also understand that there should be some other targets for the lawmakers. So one of them is the principle of systemic principle. So the cases, the compositions that the Bank of Russia will take over, that could be singled out in the one chapter. And we could also borrow from the experience from different segments of the market. It may be more developed in the insurance market, less developed in the microfinancial activity market, but we can take it on board as well. Probably just preventing some other punishment by using the coercive measures. And going back to administrative measures. So there's another principle of proper proportionality, which is quite important, and there are two things that I would like to focus on in the first place. Number one thing, which is not in the draft law, is the right of the judge just to appoint the just lower limit punishment. So the range of punishment, in particular relating to issuers and other personalities. And also we can try and discuss another issue, the issue of differentiating punishment depending on the financial indicators of the financial organization, which is quite a difficult theme for discussion. This is new for this jurisdiction, and sounds like a subject for quite a heated discussion, and I hope that with due contribution from legal profession, these issues will be resolved. The question, disqualification of the top manager of the company as a result of this procedure. On the one hand, it doesn't lead to the fact that the company terminates its activity. It doesn't make the situation of the company worse, because in my practice, if you award a fine to minor companies, we have a lot of companies that have about 1 million on their balance. So just by imposing a big fine, we formally terminate the activity of the company. So to what extent do you think this measure should be also part of this system? So this measure exists in the banking sector. It is not probably called as disqualification. However, in essence, it's disqualifying. When we approve certain people for certain positions, we also are governed by their business reputation and years of experience in the field, so we can use that. There are also specific measures that require just standing down of this person from the credit organization manager. We have less experience with that in the administrative law in the non-credit organization. This is a judicial decision. In terms of the oversight measures, it can be a different thing related to the banking sector. I think it sounds quite convincing, and there are many questions that could be resolved using these instruments. Who would like to speak up? So we left about 20 minutes for Q&A. So if you would like to offer a comment or a question in terms of the themes we have been discussing, you're most welcome, please. Good afternoon. Alexander Smirnov, public just companies from stock exchange. 5 blocks of questions. But first I'd like to ask about the corporate governance. We need to distinguish between the issues of stock and issues of bonds, and the question has been resolved. So this is the listing rule of the Moscow Stock Exchange. If we say that the issuer has to follow the best practice and the code of corporate conduct that was recommended and approved of by the Bank of Russia, automatically this is taken on board in our listing practices and rules, because we have a certain list of issues. In terms of the bonds, we don't have these requirements. The issuer has to follow certain things in terms of solvency, credit, and financial risks. But in our infrastructure, this delimitation is quite clear and is being applied. But as to the concern, how we can coerce the issuer to stick to the corporate conduct code, so it has already been achieved. If you want to be listed in the top listing system, so you have to be compliant. So in our view, the benchmark in the corporate governance is that it's quite a difficult thing, especially dealing with the top management. If you want to be in top listing system, you have to follow all these guidelines and be compliant. So this is quite a simple vector in order to ensure compliance with the corporate conduct governance conduct code in our flags. So the world is developing. There is things like subordinated debt and converted bonds. A person who buys a convertible bond, then he can further convert it into a stock. Likewise, if I'm viewed as on the same footing as the stockholders, it is my concern how the corporation is governed. On the one hand, we also confronted with certain cliff effects. So when you exclude such a bond from open sale, so it entails fire sale, which entails drop in the price and also infringes minority holder rights, and it destabilizes the financial institutions' activities. Of course, we can't completely exclude the cases when the company is withdrawn from a listed. However, that should be the last resort thing, to take some coercive measures so that the corporate governance is rectified and preventing the company from abyss. Do you have any control mechanism in a situation when the issuer ticks off compliance with the code of corporate governance? But I don't understand how you can ensure efficient control over the declared compliance. So how can you check and enforce this? It's a good question. Thank you. We have a good mechanism. We have quite a big listing department with a technical control in terms of the issuer's report is quite developed. So we annually review and evaluate the issuer's reports, and we also require information disclosure to a certain extent. Yes, from practical viewpoint, it is quite a just challenging thing. However, there are many issuers who either ignore our query for certain documents and compliance proof, but then we just work with such people. We just use the delisting procedure or just withdraw a person from the top listing system, but this is an exception rather than a rule, quite a last resort measure when people do not respond to our queries or invitations. But people should understand that this is not as this company is not as good as it used to be 5 years ago when we included it in our listing. As to implementation of this control system, it's a challenge, but we are dealing with that and quite effectively. May I bring us back to the financial ombudsman as a person who just headed the analytical department of the Supreme Arbitration Court. So the financial ombudsman will never become successful unless it's his ship. So you can never force the bank to follow the ombudsman's recommendation if it's more profitable to go to the court just to pay a little sum as a duty, just to pay cost of the court, just court duty, a low price. So for banks it doesn't provide there is no good reason for financial mediation. So just a very low sum of the court duty and the very negative court practice in terms of compensating of the court expenses. I can give you a personal example of my own communication with the financial ombudsman. I just wanted to save this intrigue. So I had a very interesting story with one of the major banks when at 11:58 in the morning I said the query in terms of exchange rate from rubles to euros, but then the bank proceeded it, just took longer time to process this and just charged 30% on top of the original sum. So I wrote to the technical support service, and they sent a very polite answer. Unfortunately, we can't do anything about it, but you can go to the financial ombudsman, and I did. He says, of course, we're not right, and just I was paid these 30 rubles back. However, it might be due to the fact that I knew this colleague very well. Otherwise, I could go to the court in 4 to 5 months. I could win, and the bank would relieve this claim. So just first they will withdraw this sum from my account, but then they will repay that. But it's zero efficiently because the bank wouldn't lose anything in this situation.
Well, the thing is that the formula of paying for the Ombudsman Institute, that depends on the number of cases that Ombudsman dealt with. And the second component is related to the defects of the products as such. If the bank maintains, so that the bank can just pay more to the ombudsman and not fulfill the decision. So the law will try to provide some financial incentives for the enforcement. Well, you know, there was a mistake in Sberbank. They set the wrong exchange rate. Some people made this conversion, and now we're having this trial. So would ombudsman be useful in situation, and how? Well, if we have one case that could set an example, that would be highly didactic. If, well, I had this power, I would assemble 5 or 6 clients. As a lawyer, I would earn a lot of money just defending their rights, and then the bank would suffer serious damage. So, having gone through that procedure once, the bank would realize that there is no other way but losing the case, and then they would be more responsible. And this is an axiom, and such mechanisms are not in place here, and all our talks about mediation and all that, they're just empty words. I fully agree with Roman. There is an economic incentive for everyone to bring their cases to ombudsman, but then there, in all the jurisdictions, there's also such an important aspect as respect towards ombudsman on the part of the courts. If the ombudsman is not a lawyer but an economist, he comes to his position and starts tackling cases like described above, and those cases then come to court. And then the court passes a totally different verdict, not understanding the logics of ombudsman, but following the letter of the law. Then that means that this ombudsman can suffer total failure. In Germany, they found resolution of this problem on a personal level. So the head ombudsman is former chairman of the Supreme Court. He retired on pension because of his advanced age, and then he was invited to become an ombudsman on insurance issues. So all other members of that board are just former bankmen. They either so they were chairmen of the committees of the Supreme Court on appropriate cases. So they have legal culture in them, and they follow its principles, and so it was this personal level approach, even without passing a specific law. But just that brought them to total mutual understanding and mutual respect between the system, the state court system, and the Institute of Ombudsman. I know a lot of lawyers who are now out of job and who are highly knowledgeable about the economic issues. Okay, let's invite the participants from the audience. Vinnikov Dmitry, a lawyer. I have certain doubts about the financial ombudsman project. And I have another question on mind. Probably the idea of creating this institution is right. As of late, we are getting more and more ombudsman on various issues, and we are probably borrowing the American experience in other human, so to speak, spheres. But my concern is about the following. You want to set the norm according to which turning to a financial ombudsman will be mandatory before going to court, before making a court claim. So I doubt about that, because ombudsmanship is based on trust and professionalism of mediators. And this suggestion will probably make this function more state-controlled. So, if you remember, we had the same debates about the tax disputes. In this particular case, I think that citizens will be estranged from, or probably even excommunicated from justice. They will have to waste their time in this useless relationship with ombudsman, and they will lose a lot of money because of that. And as of late, some major banks have gone bankrupt, and the control measures on the part of the central bank and over major banks, non-credit financial organizations, and small banks, microfinancing institutions, was rather serious. But banks set up microfinancing organizations. They insured the investments into those. Then they had affiliated insurance companies, and even when the licenses are recalled, those insurance companies, they do not pay for the damage, and so on. So then, even though there is this rigorous control, there is a huge hole in the banks of 60 to 80 million rubles. Probably we should ban this direct affiliation with other organizations like insurance ones. Probably we should delimit the banking margin. Maybe some other steps should be taken in order to prevent such things. Because those internal deals between banks, it's fine, but how can we protect the citizens who come to a microfinancing organization? They give their money, they trust the bank, they trust the regulator who had given that bank the license, and then they find out that they can't get their money back at all. Well, the business models of microfinancing organization actually implies crediting population, but not taking money from citizens. And the threshold that is being set, it's, I think, about 1.5 million. That is the minimum deposit. So that probably implies that professional investors come to that sphere who are knowledgeable of this sphere of microfinancing. So this institute is not for just attracting citizens' money, and we are not planning to develop it this way. So the liabilities, well, there should be money allocated by legal entities, then issuing bonds with high nominal value, and it shouldn't be people from the street. It should be people whom banks know, those microfinancing organizations know. And then MFOs must explain clients that there are credit risks, that their deposits there are not insured, and so on and so forth. As for the financial hole you've mentioned, I believe that we can endlessly make regulation more and more rigorous. But it should be kept in mind that regulation is for the people who are ready to obey, but not for those who are ready to disobey. If you ignore them or all the limitations. If you are focusing on the fraud, it doesn't mean what kind of barriers are installed, but that would decrease the compatibility of the market. So how to minimize the losses? It is corporate practices with in-depth, including criminal responsibility that should be enforceable. Wall Street, celebrating 10th anniversary of Ullman and Oxley, just admitted that that law saved the American market, even though at first the response was highly negative, and for several years the attitude to this law was very negative. There were lamentations like you can't even compare to the famous Russian poetry. So, but when you know that you can go to prison for several life terms, then this stops you from infringements. And there are no other ways of stopping those leakages. It's only creating downside. It's only just creating for specific physical persons who are the source of such violations. They must know that they have a risk of going to prison and all that. And it should be the risk that multiplied by the enforceability. No other steps would give this effect. And may I, well, you voice some doubts, but as for those holes in the banks, so those prohibitions on affiliation and so on will be useless. Others will think about how to go around that. So right now, well, there is a risk for the loaners and the law about the risk for loaners and so on, but it is again being gone around and done, and it is done very cynically, saying, central bank always inventing things, we must develop business, we must build production and so on and so forth at any cost. And as for the risk of and the damage to the market, this is not within the focus of interest of the violator. And then there are two ways. And these, well, among other things. And first of all, what's done in the legislation, and this should be noted and emphasized. There is and there must be the right of the regulator to pass professional judgment about the affiliation between the entities. Actually, this practice has already emerged, and it is going to be enforced. Number two, as Sergei Anatolyevich said, it's the response to the violations and frauds. I would also like to focus your attention on the fact that due to the efficient performance of the agency on the deposit insurances, so the owners of banks are sometimes brought to court for fraud, creating precedents, and just for this deliberate bankrupting banks. And in economic and just also now we can punish for false reports. If there are some falsifications in the reports, then that sets the risk for the bank head manager. And now banks are already beginning to think harder about the choice between immediate profits and the risk of conflicting with the regulatory agencies. So what are you saying? No. Much more cases. The number is greater. You can see it even from the newspaper. So, but this is the law enforcement practice issue. Yes, Dmitry Ivanovich also mentioned the topic, which is about the legal arbitrage. Yes, we have some strongly regulated banks And then we have micro financing organizations and some other non-financing, non-credit financial organizations. So you mentioned this issue of just attracting citizens' money. Here, the legal arbitrage is not that rigorous, but as of the 1st of July, we'll have more rigorous norms for the cost of credits. Banks, we will set the interest rate. The maximum being 55% a year, and microfinancing organizations will have the ceiling of 800%, and it will be totally legal. And here, arbitrage will become efficient, because it will be interesting for the banks to just refocus onto microfinancing procedures. And so we believe that such mechanisms on the level of regulator will enable us to spot out illegal manipulations like this. Are there any other questions? Since we've run out of time, and we've covered 5 large topics within an hour and a half, do you think it was efficient? Or should we rather have discussed only one topic but in depth? Who thinks that 5 briefly was a good idea? Who believes that one topic in depth would be a better format for this kind of discussion? Thank you for your attention, and in the future we'll continue using this format.